Hello, welcome everybody. This is a meeting of the Policy Subcommittee for the Freetown-Lakeville School Committee. Before we get started, we have to call the roll.
Stephen Sylvia.
Here.
Will Sankowitz.
Here.
Jennifer Blum.
Here.
John Burke.
Here.
We also have Jean Fox.
Here.
Mr. Strauss and Kelly Gonzalez.
Is anyone recording the meeting outside of LakeCAM?
I am.
Could you just name and...
Samantha Gomes.
Samantha Gomes, Freetown, thank you. Moving down the agenda, so concerns have been brought up recently at school committee meetings and then late last night and through the day through email about parent rights and student rights around the topic of gender identity support and student records. Given this is a emotionally charged issue combined with an evolving legal situation, I am hoping we can take a practical approach in using this session as an information gathering session. I want to be clear up front that we will not be creating policy tonight or recommending policy. We want to take the concerns that were raised and vet it through our legal representative, Attorney Gonzalez. We will also, there is consistent with past practices with subcommittee meetings, we will not have public participation as part of this. However, I would encourage, and based on emails I've gotten today and feedback I've gotten, we're not ready to move to the policy phase, but we do have a general school committee meeting tomorrow where public participation, is on the agenda. I would encourage people to do that. Given that, so before we start the discussion and open it up to the committee members, I really want to use the time today to kind of go through questions and raise the concerns with the attorney here. I have a number of questions that I've gotten from people in the community and through emails, and then questions I have for myself. I can keep talking, but I could throw it out there for discussion now.
I support that.
Okay.
Yeah, I say you ask your questions.
Yep. All right, so why don't I go first? In no particular order. So why don't we start with, two issues came up, and I'll start with an email today. Maybe we can get this out of the way. I had a number of emails that were fairly consistent around these two topics. There were 2 points included. One of them was a point about student records, which I think we'll get to later. The second was emails, and I assume all the committee members got it, about surveys. I want to clear out the survey aspect because I do believe we have a policy around surveys already that is opt-out. I think that we can look at that at some point as part of business for this committee and look at the consistency with MASC, but how that quality does. So for the group that emailed today, I want to be fair that we do have a policy in place around surveys. I guess this would be now a question for Kelly, and we could start with student records on a simple platform. It has always been my impression that you need legal documentation to change student records, which the assumption would be parents are involved. Could you just clarify how the law looks on that at the moment, given the legal complexities in evolving? If you could perhaps touch on FERPA or not, but any state law, FERPA, or even case law, and how that any policy decisions we make would impact that.
Sure. So I'm going to refer to a couple of documents. I guess I'll start at the very basic level, which is that Massachusetts has a law that prohibits discrimination on the basis of gender identity. And I do want to make clear that you do have a policy in effect that addresses that, which is your non-discrimination policy. I believe it's AC. So you're required to have that policy, and you do in fact have that policy. So I just want to start there so we're aware of that. The Mass Department of Elementary and Secondary Education, known as DESE, has what's known as a guidance for Massachusetts public schools, creating a safe and supportive school environment. It's a guidance on their website. One of the things they talk about is name changes and gender markers on student records. You actually don't need to, Massachusetts recognizes a common law name change, so you don't need to go and formally change your name to be known as a different name. So common usage can be a basis for a name change. There's also a frequently asked questions non-binary gender marker FAQ on the DESE website. And it actually says, is a court order or legal documentation required to verify a student's gender identity? And the answer there is Massachusetts law recognizes common law name changes. An individual may adopt a name that is different from the name that appears in their birth certificate, provided the change of name is done for an honest reason with no fraudulent intent. Nothing more than formal usage is required. And then there's the next question is about, which I think is what the question's getting at, parental guardian permission. And the student record law is sort of broken into 3 categories based on student age. So under the age of 14/9th grade, the parent has a right with respect to student records. So all student record rights rest with the parent in terms of, changing the records, identifying the records. I'll get back to that in a second. For students ages 14 until 18, and by 14 I mean either 14 or entering 9th grade to 18, the parents and the student share those rights, so either the parent or the student may act with respect to changing a record. And then from 18 on, the student is an adult. So barring a guardianship or something, for example, someone with significant special needs, the student has the right to change their records. That said, that's with respect to records specifically, but the DESE guidance also says that a student, once they can start advocating for themselves, may ask to be known by a name other than the name they were given at birth. So even if their records don't change necessarily, they can ask to be called a different name. And that could be as simple as someone whose birth name is William going by Bill, or Will, as the case may be.
So just a follow-up question, that a physical name change on a student record, so what constitutes a student record? The physical change or the asking to be called a different name? Is there a distinction in the law?
So
That makes sense.
I don't think I understand your question, so I'm going to answer it a different way.
I guess I really want to know what constitutes a student record
Sure.
in schools?
I can't hear.
You can't hear?
No, I can't.
There's some seats over here if you'd like to sit over here.
So I actually printed out the.
We can,
If it's gonna
we can
help,
try, we
then
can try to
yes,
speak
I
up.
would love for you to all move. I would love it. Get closer.
Move the table. It's jumbled.
That's okay.
So, is that better?
Not really.
Good.
Yeah, okay. So I printed out the mass regs. FERPA has a similar definition. Student records are defined by law. Under Massachusetts, it's 603 CMR 2302 for those who are keeping track. And there's a temporary record and physical record. So basically it's, and I'm very much using a shorthand here, it's documents that identify a student by name and have educational importance. So for our current purposes in terms of gender markers and names, we're talking about physical documents. So, their report cards, their progress reports, things like that. A quiz or a homework assignment or what you call a student in class. Someone raises their hand and you call them, that's not a student record.
Okay. Thank you for that. I just wanted to know if there was a legal distinction.
And just to be clear, not every single written document that names a student is a student record, so there are distinctions.
Okay.
My question is, you were saying between a physical document and them calling a name.
I apologize for this. This would be,
I'm just trying to understand what you said because it didn't make sense. And so they could have a name on the report card, but they could be called a different name
yeah, and that's
at school?
I think that's the distinction.
That's what I'm
and
trying to understand. And
I think if we could maybe have the site of the law, like where that is, we could look that up or provide that documentation. But we're trying to, I don't want to circumvent the process, and I want to be true to the
I'm just trying to understand. I was
agenda.
following it, but then
Yep.
it got jumbled. So I'm asking a simple question. I think everybody else wants to
And
know
I think that speaks to the evolving law issue that we're dealing with on the student record piece. So could you just, the CMR, could you give me that?
Sure, so the student record is 603 CMR 2302, has the definition of student records. To be honest, it's not going to explicitly answer your question. It has sort of a roundabout definition of student record. The DESE guidance that I mentioned earlier, it's available on their website. They have a Safe Schools Initiative webpage. I don't have the URL in front of me, but it's pretty easy to find. That will give you the information that talks about student records. There's a pretty clear section on it. There's actually a section that's privacy, confidentiality, and student records. So that has that information. So that, you know, it sort of draws the distinction between student records where there's sort of more clarity in the law of sort of who has rights to what versus informal name usage.
Thank you.
Sure.
So I guess a further follow-up to that would be, and policy is difficult at the local level, but an attempt to either expand rights or limit rights that either circumvents the law or works against the intent of the law would, in effect, be good policy, bad policy, or?
I mean, you can't write a policy. I would strongly advise against a policy that is
And I
contrary
think
to the law
I-
of Massachusetts, right? So you can't have the law in Massachusetts is you cannot discriminate against gender non-conforming students. So you can't, that means you have to have a safe and supportive environment for transgender students. There's a case out of Ludlow that was decided on a motion to dismiss in the District Court of Massachusetts this fall. It's currently appealed to the First Circuit. Briefs are due around now, so the decision isn't out yet. So, but bottom line, it was actually decided on a motion to dismiss, and under a motion to dismiss, the facts are accepted as true, even if they weren't. But the facts, as alleged, were that Ludlow had a policy where they wouldn't tell parents if students were transgender, and they told the school and said, "Don't tell my parents." And the court said, "That's okay. We're not violating parents' rights. We're not violating the law. That's consistent with your obligations not to discriminate against transgender students." I think that's consistent with what DESE says. That's consistent with the law, and that's what the only precedent we have so far on this.
Could you read that? Could you read that from the judge's opinion, please? We'd like to hear his words, because I believe his words were that the school committee is treading on thin water.
Mr. Cronin, with all due respect, if maybe tomorrow night you
Oh,
could
well.
add that, but I think
But-
that we're trying to keep to the subcommittee, and
That is,
I hate to engage like that, and
but she's.
I didn't create the process, but the question is, on the protocols of the meeting,
Yeah.
I will certainly, we could look at what the judge specifically said, but I think the point that I was trying to make through my question is, there is an appeal pending on this. I've also haven't been able to find much in terms of policy around the Commonwealth or beyond in terms of on this topic where student records and gender identity support, as not many districts have that. I guess my concerns would be, and I think your recommendation is, it's an evolving legal situation that goes beyond the scope of what I frankly think, and this is just me speaking, the district can present in terms of policy, but I would be concerned or curious to read the judge's decision, but also act on a policy at the moment without hearing from everyone else in the community, but also letting the legal landscape sort of settle a bit would be what I'm thinking. Other questions from members?
How old was the child in that Ludlow case?
I do not know that, but again, we're trying to, I mean, certainly, I'm sure you could look that up, but other questions from members?
They were 11 and 12, weren't they?
Yes?
I think they were 11 and 12.
So
You
how do
all
we-
have, you all have in
Yes,
front of you
11
the
and
Ludlow
12.
case,
Yes,
Right,
that's what it
yep.
says.
the judge's decision in front of you.
So not to shift gears, I guess, and I guess this is a question for the committee as a whole, right? I'm more curious around, and I think, Steve, my question is going to depend on where we ultimately fall with kind of what you just stated. Just around timeline as far as our work goes and trying to get something figured out, one way or another. I think we'd be pretty well served to be able to sit down at this table by the end of the meeting and just at least hash out several meetings in advance prior to the upcoming school year, and try to come up with some sort of timeline based off where we come in this meeting. But that's neither here nor there. I just think that's part of the work that we need to do tonight.
I just think we're in a very difficult situation because we have evolving times and we have laws that are telling us that we can't legally make decisions that, whether we agree or disagree.
I thought that it was left up to the school.
Right.
Those laws were left up to the district, we read. We read that the district was going to be allowed to do what they wanted to do with them.
Yeah.
I read it, I don't know if anybody else read it. Have you read it?
Even our state rep said that's the case.
So I think we're a bit restricted by the protocols of the subcommittee in terms of hearing from the public in this particular setting. Kelly, I appreciate the detail with your presentation. It's overwhelming. I have reservations about rushing into a policy decision, but also want to be mindful of a timeline and a process that deals with, parental rights, student rights, family rights, all around the issues of gender identity support and how it impacts student records. I think we need to take, given at least the amount of emails that came my way over the night, late in the evening, and then over the course of today, I think we need to learn more. I think, if I had a time machine, this meeting could have come after the meeting. I think we need more room for public participation at the general meetings. It's hard to sit here and try to be respectful of the protocols and shut that down, but we have a lot to learn, would be my stance on this. So that said, at least I want to maintain the position that we're not creating or drafting a policy tonight. I think we have a lot of work to do. I don't know where we go from here unless anyone has any further questions for...
I do have a question, if you could clarify this for me, please. What is currently the threshold for informing or deciding not to inform the parent? Is that simply the student saying, please don't tell my parents? Is that what the threshold is?
I would happy to, if we adjourn this meeting, I would happy to give you my opinion on that and talk to anyone outside. I've talked to a number of parents recently. I suspect it defaults to the current state case law and laws on the books at the moment that would kind of go against anything policy-wise we would do. But I'm happy to talk to you after this meeting.
Yeah, revolving around, parent involvement, right? I think we have, districts are dealing with this all over the country, right? Never mind Massachusetts, Rhode Island. If you look at North Smithfield, I think they were looking at policy pretty recently, right? And I think what their school committee did was pretty well-intentioned and smart, with the fact that they obviously had a first and second policy reading at school committee meetings, and they obviously invited for public comment at those meetings. And I think that's probably a good route for us to take when we get there. But again, I don't think we're there yet. And I think that speaks to really sitting down and trying to hammer out a timeline for what this work is going to look like and set some kind of beacons, so to speak, for when we want to have, if anything at all, based off what Kelly has told us tonight, a policy in place. So, I'm just throwing that out there, that we obviously want public participation here. We want to hear their voice. It just has to be in the right settings, right?
So we have work to do. Clearly, timeline, I think we'll have the meeting tomorrow night. Obviously, there's public participation, and I think we can probably set shortly after that a schedule. And in the meantime, I don't think that prohibits any members, whether they're on policy subcommittee or not, listening. We're all in the community and being transparent and trying to be helpful is my opinion on that. But to sit here today and pretend that we can draft and create a policy on the spot
Excuse me, Jose is asking you to turn yourself up, please. I can see him signaling you, but you're not looking over. And
Okay, sorry about that.
Nobody can hear you. So. The equipment can't even hear you.
Thank you for that.
Thank
Sorry
you.
about that. My point was, we have work to do, and I think we need to relieve ourselves of the restrictions of the agenda at the moment, and talk to community members. We are community members, and see where we go. I look forward to the public participation tomorrow night as part of the meeting, and I think we set a schedule after that. If we have consensus on that, we could close.
Yeah, so just being very clear, Kelly, so what are our options moving forward?
So, option one is at this time to not create any further policy, because your policy AC meets the requirements of the state in terms of the non-discrimination law, and then you apply the DESI guidance. And I think there is some benefit to that. I mean, policies as a general rule should be rather broadly written so that situations can be handled on a case-by-case basis with administrators taking into specific facts and managing cases as they come. Another option would be to sort of start hearing public comment, kind of starting the process and seeing how the Ludlow case shakes out. I don't have a timeline on it. Like I said, I know briefs are due around now. I can't imagine that we'd have a decision before the fall, but I don't know. I have no actual knowledge as to when that would be. But I can't imagine you'd have a policy in place before the start of the school year if you wanted to wait for that. But I can see a value in at least waiting to see where the First Circuit comes out rather than drafting a policy based on a case that's currently actively under appeal. Another option would be to start writing something sort of recognizing some general kind of truisms. You know, I mean, it's not inconsistent with the law, for example, of course, everyone wants to support children, right? Parents want to support children, the community wants to support children, you do. Teachers do. So, I mean, you can start writing a policy. I know that Alan has started sort of reaching out to see if he could find some models. You know, you can do some of that legwork and see if you find things that resonate, that work, that accomplish what makes sense to you. I mean, I think you're all saying you don't want to, there is work to do. You don't want to draft something for the sake of having something that isn't appropriate. But I also don't think you want to write something, obviously, that isn't legally sound, right, or that's going to tie the hands of the administrators to have to do something that isn't appropriate or that isn't going to comply with the law or be right for a child in a certain situation or a family in a certain situation.
Well, not informing a family isn't right, okay?
Yeah.
And you just commented, and I don't mean to take over this meeting here, but you just commented that we shouldn't be doing anything with a current appeal in place. Yet the superintendent relied on that to deny me, along with you, the opportunity to change our son's name back. So you can't play both sides of that field.
Right.
You can't do that.
Thank you, Mr. Cronin. And I would entertain a motion to adjourn if anyone's willing, and then we can sort of get out and talk to the community on that, if that. Second?
I'm not on the committee.
Also, so before we do that, anything else from the policy subcommittee that because I don't want to adjourn and then have something come up. Any other questions for Kelly? Kelly, thank you so much for being here. Anything for Kelly at this time? No? Okay, then I'll support the motion.
Yeah, and it's primarily to
Jen.
get us out of the restrictions of the agenda.
Correct.
So we can have conversations.
Correct. So, yep, Jen will second it.
Accepted.
Yep. All those in favor can signify by saying aye at this point.
Aye.
Okay.
Meeting adjourned.
Yep.